Welcome to the debate. A few phrases in American law, I think, carry the historical weight and the modern controversy of the 14th Amendment's definition of citizenship. Ratified in 1868, right in the aftermath of the Civil War. This was more than just an amendment. It was a fundamental constitutional repair specifically designed to overturn the devastating race-based exclusions from the Supreme Court's decision in Dred Scott versus Sanford.
And at the absolute heart of that repair is the Citizenship Clause. It states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. And, well, the whole conversation we're having today really pivots on those 5 words, and subject to the jurisdiction thereof.
Exactly. I mean, those 5 words are the entire legal battleground. Do they just require territorial presence? So, if you are born here, you are a citizen? Or do they impose a much stricter demand for, say, complete political loyalty, which would exclude vast numbers of people born right here within our physical borders?
And that is the central question for today. I'll be arguing for that traditional, broad, territorial interpretation. I'm defending the long-standing legal precedent that grants citizenship to nearly everyone born on U.S. soil under the common law principle we call jus soli, the right of the soil.
And I am going to present the case for a more restrictive reading, one that demands full political allegiance. This interpretation, I believe, holds that the children of unauthorized residents, or even those just here temporarily, they maintain a primary allegiance to a foreign power, and therefore, they just don't satisfy the 14th Amendment's strict jurisdictional requirement. So my argument, it really begins with history and precedent. The 14th Amendment, its goal was to constitutionalize the foundational principle of jus soli. I mean, for centuries, going all the way back to English common law, birthplace defined citizenship. If you were born on the territory, you were a subject. It didn't matter what your parents' status was.
But you're relying on the common law. The framers added those 5 words, didn't they? Presumably to modify or restrict that same common law.
To dismantle the post-Dred Scott reality. And that intention was fully realized by the Supreme Court in 1898 with United States v. Wong Kim Ark. Now, Wong Kim Ark was born in San Francisco to parents who were Chinese nationals and this is critical, they were barred by the racist laws of the time, the Chinese Exclusion Acts, from ever becoming naturalized citizens.
A crucial fact. I agree. A crucial fact.
Right, and yet the Supreme Court unequivocally confirmed his citizenship. They ruled that subject to the jurisdiction thereof simply means being subject to the territorial reach and authority of U.S. laws. You know, the same laws that protect you and also subject you to enforcement. The only exceptions they carved out were incredibly narrow and based on sovereign immunity. So children of foreign diplomats, invading enemy forces, and at the time, certain untaxed tribal members. Children of all other aliens were and have been for 125 years included. This broad interpretation, I would argue, is inseparable from the entire purpose of the 14th Amendment. It was forged to prevent the creation of a permanent, inherited, subordinate class, what we might call a constitutional underclass, of people who live here, work here, pay taxes, but are perpetually denied civic rights. To let birthright status hinge on parental status, well, that just reintroduces the very hereditary distinction the amendment was meant to abolish.
I understand the historical imperative, following the Civil War, and I absolutely respect the gravity of the Wong Kim Ark ruling. But I think the territorial reading, it just ignores the nuances of political sovereignty that are embedded in that phrase, subject to the jurisdiction thereof. Mere physical presence and being subject to our criminal or civil laws, that's just not the full meaning of jurisdiction in a constitutional sense. So proponents of the restrictive view, they argue this phrase requires full and complete jurisdiction, which implies not just physical control, but a complete severance of political fealty or political loyalty to a foreign sovereign.
And where do you find that standard in the law?
Well, it has its roots in an earlier Supreme Court case, Elk v. Wilkins, back in 1884. That case involved an indigenous man who had voluntarily left his tribe and settled among white citizens. The court denied him citizenship, arguing that despite being physically present, he was not subject to the complete jurisdiction of the United States because he owed, and I quote, immediate allegiance to his tribe. which was seen as a separate political entity. Now, while elk isn't applicable to Native Americans anymore because of later legislation, its core rationale, that jurisdiction is linked to political fealty, that was the foundation of the very powerful dissent in Wong Kim Ark. And that dissent argued that jurisdiction requires the parents themselves to be non-aliens, or at the very least eligible to become citizens, which would confirm they had no competing foreign allegiance. And this, right here, this is the legal theory that's driving modern efforts to narrow the clause. For instance, Executive Order 14,160, introduced in 2025, it specifically relies on this idea, asserting that children born to mothers who are unlawfully present or whose stay is lawful but temporary should be excluded. Why? Because the parents owe primary allegiance to their home country and are thus not completely subject to U.S. political jurisdiction.
Okay, but let's focus on the precedent. The majority opinion in Wong Kim Ark was fully aware of the Elk ruling. They actively chose to reject the political allegiance standard for the children of resident aliens. The facts of Wong Kim Ark involved parents who were expressly ineligible for naturalization. I mean, that's as close as you can get to owing allegiance to a foreign power while living here. And still, the court confirmed the child's citizenship. And what's more, we have over 4 decades of precedent confirming that even someone here unlawfully is definitively subject to the jurisdiction of the United States. In Plyler v. Doe in 1982, the Supreme Court determined that undocumented immigrants are fully subject to U.S. law, and they noted, the undocumented status of these children does not place them outside the scope of the 14th Amendment's guarantee of equal protection.
But you're conflating 2 different standards of jurisdiction there. The Plyler case, it addressed jurisdiction for the purpose of the Equal Protection Clause. I mean, whether they were subject to the laws for purposes of, say, receiving education or avoiding discrimination, being subject to the laws for enforcement is just not the same as being subject to the political jurisdiction for the purpose of defining sovereignty and citizenship. And I find it compelling that modern challengers argue Wong Kim Ark is confined to its facts. Wong Kim Ark's parents were domiciled residents, what we would now call lawful permanent residents, or LPRs. The Supreme Court has never definitively decided the citizenship status of a child born specifically to a parent who is here temporarily, or a parent who is here without any authorization.
But if they are physically here, they're subject to enforcement, to deportation, to taxation. How is that not jurisdiction?
It is territorial jurisdiction, sure, but not complete political jurisdiction. The narrow reading aims to convince the Supreme Court that the Wong Kim Ark majority misunderstood the constitutional history, and that the rationale of the Wong Kim Ark dissent, and really the spirit of Elk v. Wilkins, should control for anyone who has no established legal or political connection to the U.S. The goal is to carve out a constitutional middle ground. And look, let's look deeper at the legislative history you cited. The 14th Amendment Citizenship Clause, it replaced language in the Civil Rights Act of 1866, and that earlier act explicitly excluded those subject to any foreign power. When Senator Lyman Trumbull, who was a key architect of the 14th Amendment, discussed the revised clause, he insisted the key concept was, quote, not owing allegiance to anybody else. If the framers really intended unconditional jus soli, why even bother with the phrase at all? I mean, they were specifically trying to distinguish between those who had fully integrated into the political community and those who still maintained competing loyalties. They chose language that, when you read it in its restrictive context, suggests a requirement of political fealty.
Well, I think that's a very selective reading of the history. We have to consider why they chose to use the common law standard and then inserted those clarifying words. They were addressing a fear. The fear that this new constitutional guarantee would be read so narrowly it would only apply to formerly enslaved people. They needed to assure Congress that the clause was merely restating the common law as it was understood at the time, and more importantly, the historical record. It shows they debated the consequences of a broad reading, and they accepted them. They knew they were granting citizenship to the children of people they considered undesirable immigrants. Senator Conness acknowledged that the children of Chinese immigrants would be citizens. They accepted this. This breadth is the necessary price of fixing the constitutional flaw of Dred Scott.
But isn't it worth considering that the U.S. model of birthright citizenship is now an international outlier? We derived jus soli from feudal England. And yet countries like the UK, Australia, many others have either abolished or severely restricted unconditional just solely since the 1980s. And they did it primarily because of concerns about managing immigration and ensuring a genuine connection to the nation. This global trend, while it's not legally binding on us, it does suggest that the broadest possible interpretation of the 14th Amendment is not some universal norm of modern sovereignty. And it undermines the idea that this expansive reading is somehow absolutely necessary for a modern republic.
But it has no bearing on our 1868 constitutional text. The framers made a deliberate choice to lock in this definition of citizenship into the Constitution precisely to prevent it from becoming subject to the whims of legislative policy changes responding to immigration pressures, whether those pressures manifest here in 1898 or in the UK in 1980. That permanence is the point. Any attempt to change this without a constitutional amendment is challenging the very foundation of Reconstruction-era constitutionalism. And let's pivot to the policy implications, because the practical mechanism of adopting your narrow political allegiance standard is, well, it's frightening. If we just discard the clear, objective, verifiable rule of birth on U.S. soil, how exactly would the U.S. government practically determine complete political fealty at the moment of birth?
It would be determined by the parent's status and intent at the time.
But imagine the bureaucratic nightmare. Birth certificates which have been definitive proof of citizenship for over a century, they would suddenly become meaningless. Every single citizen would potentially need to prove their parents' legal status and their intent at the time of their birth. This would create an incredibly complex, expensive, and invasive bureaucratic process for every single person, not just the affected population. But far worse, I think, than the administrative chaos is the social cost. Adopting this standard would instantly create a multi-generational class of people, millions, born here, raised here, educated here, who have no real allegiance to any foreign power but are denied the fundamental rights of citizenship. They would be here permanently, yet fundamentally subordinate. This revives the exact social and constitutional hierarchy that the 14th Amendment was explicitly designed to eradicate. It is, frankly, a formula for social instability.
That's a compelling warning about social stability, but I think you exaggerate the administrative complexity, and you're overlooking the policy problem the restrictive interpretation is trying to solve. The status quo, at least in the view of its opponents, acts as a perverse incentive that rewards temporary or even unlawful entry with the permanent prize of citizenship for the child. The challenge here, whether it's through an executive order or a statutory change, it's precisely about protecting the value of U.S. citizenship. If citizenship is just an accident of birth without any requirement of legitimate political ties, some argue it diminishes the sanctity of that status.
But if the problem is immigration incentives, then you pass effective immigration law. You don't engage in constitutional reinterpretation that targets children. How do you respond to the charge of creating a constitutional underclass? These are people who, according to your theory, might owe allegiance nowhere, since they were born in the U.S., and their parents' home country often won't grant them citizenship either. You're effectively condemning them to statelessness.
Well, that assumes the other country won't recognize them. Many nations operate on jus sanguinis, or citizenship based on blood, so the child would have citizenship elsewhere. However, even if they don't, the question remains, should the U.S. be compelled to grant the highest form of political status based on a mere accident of timing and location? And the political coalition pushing for change is serious. The fact that they are simultaneously pursuing multiple, sometimes contradictory paths, an executive order, a statutory bill like the Birthright Citizenship Act, and the constitutional amendment, it demonstrates a deep substantive commitment to revisiting the Wong Kim Ark precedent and prioritizing political fealty over simple territorial presence. They are unified in the goal of changing the policy, even if the legal mechanism remains unsettled.
We return, then, to the fundamental division illuminated by this material. For over 125 years, the principle of jus soli, based on territorial presence and subjection to U.S. law, has defined who we are. Any attempt to unilaterally redefine the 14th Amendment through executive action or a simple statute, it challenges the foundations of democratic equality laid down in Reconstruction. It threatens the stability of American identity by making citizenship contingent on the unpredictable status of a parent.
And the unresolved legal question remains,
whether the Wong-Kim Ark precedent, which is rooted in the facts of lawful permanent residence, truly applies with equal force to those who have no established legal or political presence. The entire debate hinges on whether that phrase, subject to the jurisdiction thereof, requires only subjection to U.S. law enforcement, or if it demands the complete political loyalty that was articulated in the earliest interpretations of the 14th Amendment, like in Elk v. Wilkins.
We've explored the tension between historical precedent and political theory concerning these crucial words, and it is clear that the definition of American citizenship is not nearly as settled as many might assume, but really remains a contested constitutional concept with immense implications for our nation's future.
The material demonstrates a profound legal disagreement that sits right at the intersection of history, law, and modern immigration policy, leaving the listener to weigh which standard, territorial presence or complete political allegiance, best fulfills the enduring promise of the 14th Amendment.